Hello everybody, my name is Helen Stacy. I direct the program on human rights in the Centre on Democracy, Development and the Rule of Law at the Freeman Spogli Institute, and also teach international human rights here at Stanford Law School. I'm delighted to be chairing this second session entitled Prosecuting International War Crimes, Lessons Learned and the Road Ahead, although I think we talked a bit about that in the last session. So the key part about this session is that we have a triptych of wonderful speakers who each of them represent a different piece of the prosecutorial process in international criminal law. I guess because you're right in the middle, the rose between two thorns, I'm going to introduce you first, Shamila. Ms. Shamila Bentu, who in fact will be our first speaker, comes to us from the ICC, where she is the senior legal advisor to the prosecutor. At the end, on my far left, is Professor David Kaye, who in his second career is at the University of UCLA, where he is executive director. You have so many titles there, David. I have to read it. Executive director of the International Human Rights Program and director of the International Justice Clinic at UCLA. And in his previous life, when he was with the US State Department, was in The Hague, where he was counsel to the US on several important matters, including matters before the ICJ and also the Iran-US Claims Tribunal. From 1999 to 2002, he was the State Department's principal staff attorney on humanitarian law. And if you think back to 1999 to 2002, there was a lot of action in that arena where the US had involvement. On my left, I have can I call you a living treasure?
Call me Ben. Benjamin.
Mr. Benjamin Ferencz, who made history by prosecuting the Einsatzgruppen cases, really, before the Nuremberg Tribunal. I think I see some of the students from my international human rights class last winter, where we studied the Einsatzgruppen cases as that particular specialty that the Nuremberg trial heard, where simple affiliation to a particular group was sufficient to attract indictment and subsequent prosecution and charge of the 22 cases that you brought before the tribunal. I want to congratulate the organisers of this wonderful conference for singing a collective happy birthday, I promise I won't lead you in the song, to the ICC, and to let you know that in the program on human rights, we think this is such a significant phenomenon in international human rights process that we are next year devoting the whole of our year to the issue of the International Criminal Court. So together with my manager, who was here, Nadezhda Marquez, and my collaborator, Professor Richard Steinberg from UCLA, we are devoting a year of activities, including research projects and workshops, an entire winter of speakers who will come to our winter speaker series, and depending on what comes out of that, potentially ongoing research projects. So it's a particularly significant issue that is, I think, meriting of ongoing analysis and understanding. The order of proceedings, as I mentioned, is that we'll have ladies first. I want to say a little bit to you about Shamila because she's a very significant attendee today. She's one of probably the only other person in the room who understands the arcane sport of cricket. I don't know if there's any other refugees from the former British Commonwealth in here. But Shamila was a significant role, played a significant figure in a case known as the King Commission. Could I call it the King Fixings? It's a King Commission, but it was really about fixing payments to cricketers to fix the outcomes of cricket cases. And cricket's almost like a Masonic code if you're part of the former British Commonwealth. It's a very stately and graceful game, has been analogized to watching paint dry, and I think it's the only sport where one breaks for afternoon tea. Actually, what they put in the teacups is gin, but it makes sure that people stick around. In addition to that extremely important role, you should know that Shamila in 1995 was appointed by President Mandela to investigate the hit squad activities in KwaZulu-Natal. That said, without even one glass of wine, from 1995 onwards. And this was a really important part in post-apartheid South Africa in that interim period of an interim constitution and now the 1996 constitution that has the longest Bill of Rights in the entire world. The biggest, longest, most complicated Bill of Rights anywhere that you can see. I'm going to ask Shamila to kick off. I should say have the first innings, really, to be completely consistent, and then ask David to then follow in the second innings. Both Shamila and David are going to take about 15 minutes. In recognition of Benjamin's status as a human treasure, living human treasure.
Youngest and the tallest.
We promised you we're not going to stand up and personify the difference in heights. Benjamin will take slightly longer, and then we'll open the floor up. So over to you, Shamila, who's going to present from behind the desk, but does have...
If you don't mind. No, I have no PowerPoint.
Okay, yeah, please proceed.
Thank you very much, and good morning to all of you. Although my clock is in the afternoon, but thank you very much to the organizers for inviting the Office of the Prosecutor to speak at this really important conference. And I certainly hope that my address here today would help you understand a little better how the Office of the Prosecutor functions. But I was also specifically told that the focus of my address should be looking back, at the ICC and looking forward. So I will approach it on that basis, but I was given to understand that, the focus might well be on prosecuting international crimes. So if you have any questions later on, I'd be happy to take them regarding that. But firstly to say, and I'm really particularly honored to be sharing the platform with Ben Ferencz, who is really an icon, and having been a prosecutor myself for about 25 years in South Africa, I think I can very much identify with what you've done. But I mean, that pales into insignificance when you look at what Ben Ferencz has achieved. But having said that, I think it was Alan Weiner who said that Nuremberg was indeed a landmark. But it seemed like at the time, the world was really not ready to transform that landmark into a lasting institution. There was absolutely no policy in place. Oh, my computer's gone off on standby. Sorry, can I just get this back on before? But basically, there was no policy in place to deal with the Khmer Rouge atrocities, and then we had the Srebrenica atrocities. We had all of these atrocities around the world, and there was absolutely nothing that the world could do with it. We saw Rwanda, and we saw the rapes in Rwanda, in the former Yugoslavia, and it was absolutely, there was nothing in place to deal with this. It was only 50 years later that the Security Council decided that they would establish the two tribunals, that is for Rwanda and for the former Yugoslavia, to actually deal with these two, with the atrocities in these two very specific situations. It was only with the establishment of the Rome Statute it was only with the Rome Statute establishing the criminal court that the world had the first international criminal court that had jurisdiction to deal with these atrocities in states parties that actually ratified the statute. And for the first time, we now had in the world that there was this added independent component and a permanent justice capacity to deal with these atrocities. There was now the issue of individual accountability, as you heard, and the rule of law now became very important principles. In 1998, this was really just all in paper. But one can really say, as you've heard from the judge and from the registrar, that in 2012, the Rome Statute system is really in motion. Yes, it has its challenges and difficulties. And yeah, celebrating a 10th birthday, we can't sit on our laurels and say we've done extremely well. It is really a time to reflect and to look at how we can actually better this. But the unanimous referral of Libya by the Security Council actually bears testament to the fact that the ICC has become a recognized institution and is really firmly entrenched in the international landscape. As you've heard, ladies and gentlemen, today there are 121 countries that have now ratified the statute. Bangladesh will be Guatemala will be the latest one. And they commit, yes, to investigate and prosecute these atrocities themselves within their jurisdictions, and they accept that in the event that they are unable to do so, the ICC can independently step in and do it on their territories. You've heard a lot about cooperation, but I think more needs to be said about it because it is such an important aspect of the Rome Statute system. We do not have a police force to implement the decisions of the court. And so it becomes the court depends on states, both states parties and states non-parties, to cooperate with the court so that the decisions of the court can be implemented. It was Judge Philip Kirsch, who was the ex-president of the ICC, who talked about the two pillars of the ICC. And he says you have the justice pillar and you have the cooperation pillar. Essentially, if you don't have it, it collapses. And that gives you an idea of just how important, how critical cooperation is to the efficient functioning of the court. But as you've heard from the other speakers, we've generally had good cooperation from states parties. Well, both states parties and states non-parties. We have excellent cooperation with the US as well. The DRC surrendered 3 of its nationals to the court. The Belgian police in one day implemented the arrest warrant that resulted in Jean-Pierre Bemba being transferred to the court. And France, cooperating with Rwanda, did the same with regard to Calixte Mbarishiwana. But, well, before I get to the rest, so generally, requests are well responded to. They positively responded to. In fact, we can say about 70% of the Office of the Prosecutor's requests to states are positively responded to. The ones relating to cooperation with regard to freezing of assets, with regard to interviewing witnesses, etc., they all positively responded to. But of course, the court encounters difficulties when it comes to arresting individuals, especially when they are protected by active militias or they use the state apparatus to commit crimes. And that is something you've heard the registrar talk about, that if we cannot get to a point where the states cooperate with us as far as arrests are concerned, it really is a huge challenge for the court. It is this collaborative, I think what really needs to be emphasized is that there needs to be this collaborative efforts on the parts of states as well as the court in order to really run an efficient system. Going after powerful individuals is not easy, especially heads of state. We heard the professor said that she might not have, in fact, proceeded against President al-Bashir. And it also, in addition to that, it raises other complex questions, particularly with regard to the relations between the mandate of the court and mediation and peace efforts. And the existence of the Rome Statute, we believe, has meant that only in the last 10 years, international policymakers now have the court, the international court as well, as an option that they could use in order to achieve peace and security. I think it is apparent, and if you looked at the slide that the judge showed about the number of states, the number of countries that have ratified the Rome Statute, I think it's really apparent that increasingly today, the world is united by this conviction that no leader can be allowed to get away with the atrocities or massive atrocities in order to gain or to retain power. There will be legal consequences and possibly individual accountability. For states that are parties to the Rome Statute, it's pretty straightforward. But with regard to states that are not parties to the Rome Statute, of course, that's a little more complicated because the ICC can only step in if the Security Council refers it or if the state accepts jurisdiction under Article 12.3. And it's difficult when you have a Security Council that really has to decide these cases on a case-by-case basis, and there's really not one particular standard that is applied. So perhaps the Security Council, in order to encourage changing behaviors, should consider warning states that are not parties that, if they continue with certain types of behavior, the Security Council could consider the possibility of referring the matter. I don't know. I mean, in the Office of the Prosecutor, we do have this practice of warning states parties where we think, where there are allegations and information of atrocities being committed, that the office is watching them, even before we open a preliminary examination. For example, in Mali recently, we issued such a notification, and the response that we got was, the feedback was that it was really positive in actually dealing with some of the atrocities on the ground. So that is as far as the issue of cooperation is concerned. Now, another innovative part of the Rome Statute is really, and I just want to touch on this very, very briefly, how it deals with gender crimes and crimes against children. And the statute confers on the Office of the Prosecutor a very specific duty to focus on these kinds of crimes. As you know and you've heard, the Lubanga trial is really, the charge against Lubanga was recruiting and conscripting children under 15 and using them to participate in hostilities, and that judgment was delivered on the 14th of March. I think what the Lubanga trial has really done is to highlight that recruiting children under 15 is not a lesser crime. And I think that is what is really important. People don't realize the extent of the damage in a country like in a country like the DRC, where an entire generation of children are taken away. And we were very pleased to have Mr. Ben Ferencz, who actually dealt with this, and when he addressed the court in its closing arguments. But I think what it has really highlighted is that this is not a lesser crime. And it was a fellow South African, His Excellency, the Archbishop Desmond Tutu, who said, "It is immoral that adults should want children to fight their wars for them. There is simply no excuse, no acceptable argument for arming children." Subsequent cases in the courts has also highlighted the gender aspect of crimes. We have the command responsibility in the case of Jean-Pierre Bemba, where the allegations are of an organized campaign of rapes. We have the charges of genocide through rape against President al-Bashir. So the office has really tried to focus on these types of cases. And that's all I will say for now. If you do have questions, I'm happy to take them. Ladies and gentlemen, I just want to deal with the two risks that the prosecutor identified with the office and the court at his last address at the Assembly of States Parties in December of 2011. He identified the first major risk as the risk of an isolated court, a court that promotes and stimulates legal and academic debates, but is ignored in the management of massive violence. Evidence has shown that some leaders sought by the court have threatened to commit more crimes in order to maintain power. it is tantamount to actually blackmailing the international community with the alternatives. You've heard this debate often enough, with the alternatives of justice or peace. And should these really be alternatives? Now, the efficiency of the court will really depend on how political leaders and conflict managers deal with this, what one can actually call blackmail that is placed upon the international community. The interplay between conflict resolution initiatives and justice it's a prominent feature in the work of the court. And in order to effectively contribute to peace and security, not just justice, the Office of the Prosecutor, mindful and cognizant of the political landscape, has to hold its legal limits. And that is the tension that we have. But the Office of the Prosecutor has to hold its legal limits. But you cannot act in a vacuum. You have to be aware of the external environment that you're operating in. It may require you to delay or to time certain decisions, but at the end of the day, you've got to do what the statute actually requires of you. And that is, our mandate is to investigate with impartiality and to apply the law with integrity. One would think that the failed Munich appeasement in 1938 would have actually been a lesson in the need to rethink how to negotiate conflicts more efficiently. Another risk that the prosecutor identified is a court with no independence. And I don't think people realize how important this is. Independence of the ICC should by no means be taken for granted. National interests and agendas relating to, I think some of the other speakers have alluded to this, national interests and agendas relating to politics or economy could provide incentives to control the court. And that's a reality. Alternatively, these interests would be prioritized over a state's commitment to international justice. So reality has demonstrated that the office decisions have triggered conflicts for interests for states. That is a reality. Leaders who commit crimes to retain power have criticized the court, and they have managed to mobilize some international support for this. So many states parties, notwithstanding their commitments to the court, have struggled to prioritize their commitment to international justice over what they consider to be their more immediate political interests or agendas. Some of them may at times, in fact, perceive the Rome Statute as an unnecessary constraint and try to limit its powers. And this is what we have to be acutely aware of. They do have incentives to control the court through undue expansion of states' oversight, because the states do have the Rome Statute requires that the states conduct an oversight function with regard to the court's activities. And yes, that's really important. But there is that possibility that in conducting this oversight, they would be able to exercise control over the court. As I said, ladies and gentlemen, independence without, an international criminal court without independence really has no value. Today, as I've said, ladies and gentlemen, the court is truly in motion. It's arrived at a critical juncture, the closing of one of its first trials. This developing jurisprudence of the court, as well as the policies and the lessons we've learned in our investigation, in our prosecution practices, will help us to improve the efficiency of the court. Yes, I agree, 6 years for one case is unacceptable. And we've learned valuable lessons in the process, particularly when it comes to issues of disclosure. You know, there was a stay in Lubanga, which also actually contributed to the delay in the case, and with regard to the use of intermediaries. And so we have put these into practice. But the true relevance, we will conclude trials in the court, but the true relevance of these trials, as well as the other activities of the court, will more importantly lie in the fact of the impact of the work of the court in trying to actually prevent these from recurring. This is one of the strategic objectives of the court, or of the office. And I'm not going to go into any detail. I've been told I don't have too much of time about what we actually do to enhance the preventative impact of the court. Let me give you but one example. In the Lubanga case, it stimulated debates on the recruitment of children, and it was the UN Special Representative on children in armed conflicts, Ms. Radhika Coomaraswamy, who testified at the Lubanga trial, and she said that the trial in itself, even before its conclusion, had actually stimulated debates in various countries, including Colombia, and she testified that, you know, the day before her testimony, several thousand children had been demobilized in Nepal. And I think that is what is important for the court, to have this kind of impact. Simply convicting people and sentencing them is really not going to be enough. I think the Lubanga judgment, and I really must mention this, is also an opportunity to focus states and other relevant actors on how you can actually contribute to preventing these crimes. And perhaps there's the thought to be given about including these issues in national curricula, in schools, in universities, so that, and not just in states, parties, or situation countries, but all over the world, so that young people are educated about the impact of these kinds of atrocities in the world. As I've said, and in conclusion, ladies and gentlemen, support for ending impunity is in fact increasing. We do have 125 states that have ratified. You've seen it on the map. The whole of South America, Western Europe, most of Oceania, Sub-Saharan Africa. Tunisia recently ratified, and that was barely 2 weeks after the fall of the old regime. And I think that sent a clear message that there's no turning back to the abuse of power. And the recent accession of Bangladesh and Philippines shows that there is indeed a promising trend towards ratification of the Rome Statute. But ladies and gentlemen, I emphasize again, and as other speakers have said, that there is no criminal international court, there is no domestic court that can prevent crimes on its own. We will do the legal part of it, but it's really important that the efforts of political activists, conflict resolution persons, people like you, ordinary citizens, that you integrate what you do, and that we have a comprehensive strategy to deal with prevention. Otherwise, really, the impact of the court wouldn't be felt. So with that, I conclude, and thank you for your attention.
Thank you, Shamila. That was Ms. Shamila Batohi, who's Senior Legal Advisor to the Prosecutor at the International Criminal Court. Now turn the floor over to Professor David Kaye from UCLA, where he runs the International Human Rights Program and also the International Justice Clinic.
Thank you, Helen. And thanks to all of you. Thanks especially to Alan Weiner and to students in the International Law Society for inviting me here. As a person who has 2 degrees from Berkeley, I kind of appreciate coming on enemy territory and not being, I don't even know what you do to Berkeley students. I know what Berkeley students do to Stanford students, but I also want to say that I thought that Professor Ruth Wedgwood would have kind of softened the ground for me, and that maybe to mix metaphors, that I wouldn't feel like I'm the skunk at the garden party. But unfortunately, she was super diplomatic, which leaves me as a former diplomat to be in a position of maybe not being so diplomatic. I also wanted to say that I was going to make a little riff on having a 10-year-old, but Professor Cuellar kind of stole my line. So I'm actually going to move right toward the dry substance of my talk, as much as that pains me to do. So what I want to do in the next, hopefully less than 15 minutes, and I'll rely on our chair to knock me out when I'm done, is I want to...
Madam Lash.
Yeah, a little lash, right? Just offer a few congratulations to the court. Second, I want to mention Libya, talk a little bit about Libya, and then I want to move third to a set of lessons learned, time permitting. And if time isn't permitting, I'll just whip through them very quickly. So in the category of congratulations, I want to say 3 things. First, the prosecutor had the vision to create a structure designed to analyze and act on issues of complementarity and generate support and cooperation from outside actors. This is the JCCD, the Jurisdiction, Complementarity, and Cooperation Division. And this was an important improvement over the ad hoc nature of cooperation and analysis pursued by other international tribunals. I think the prosecutor deserves congratulations for that kind of vision. I actually want to, in a slightly related way, add to this the prosecutor's vision in establishing with my colleague, Richard Steinberg at UCLA, the Criminal Law Forum, an online forum for debate and analysis of issues that the court faces. And I think that kind of effort has been something that we should congratulate the court and congratulate my colleague, Professor Steinberg, on putting together. Second, OTP, the Office of the Prosecutor, and the Registry have developed an absolutely world-class approach to witness protection. OTP has integrated a gender advisor into the work of investigators and prosecutors, and the Registry has devoted a sophisticated system for protecting would-be witnesses in the field and at the court in The Hague. Third, and finally on the congratulations, because congratulations at the end of the day are kind of boring, the prosecutor has deployed his personality to raise the profile of the court. Sometimes this hasn't always worked him from the perspective of outside observers or even internal observers, but he has become a public figure for the court whose engagement signals to would-be bad actors that the ICC is watching them. At the same time, of course, it's risky to be a public figure, to be a political actor, and maybe in the conversation as we talk about Libya and other situations, we'll see where that may have been a little bit of a problem. Okay, so those are the congratulations. Second, I want to raise the issue of Libya. So to start off with, the Libya situation was essentially literally an overnight referral. On a Friday, there was no sense that the Security Council would refer the situation in Libya back in February, this was February 25th, to the court. And then on Saturday, after some remarkable circumstances, including a tearful statement to the court by the Libyan ambassador and a letter from the Libyan ambassador to the court, we end up with Security Council Resolution 1970, which referred the case or the situation to the court. But how it developed afterwards, I think, bears some of our reflection. And there are many things we could talk about Libya. We could focus on Libya, but I want to mention three things. And these aren't really as much about the court necessarily as about the actors around the court. So the first one is, how committed actually is the UN Security Council to international justice and to the ICC? So on the one hand, the referral marked an affirmation, right, giving the imprimatur of the Security Council to the ICC. But once Tripoli fell, the Council seemed to back away, suggesting that the Libyans would decide the fate of Muammar Gaddafi, his son Saif, and his brother-in-law Sanusi. I think from the outside, this looked like the instrumentalization of the court, and that's a very dangerous place for the court to be. So second, what should be the political role of the court in these kinds of situations? So one can argue, as I've just said, that the Council instrumentalized the ICC, using it to develop support for what would become a NATO operation just weeks later, but then chucking it, putting it aside when that kind of support was no longer needed. So I want to ask the question whether there's room for the court to push back in those situations. Is there a place for the court to say, we will take on this situation, but we need the assurance of the Council's support when we actually move forward with it? That didn't happen here. It's a risky way to think about it, but it's something that I think those who are supporters of the court and the court itself need to think through. And then the third thing I would mention with respect to Libya is the question of whether there are opportunities to rethink the role of the court in domestic situations. We just heard a moment ago in the previous panel that there will be a complementarity decision coming up soon. I think the court could have thought innovatively early on, perhaps when Tripoli fell, about the possibility of, and this is something I argued at the time, nobody listened, so it was either a bad argument or nobody listens to me, that the ICC should have its trial in Libya. And there could be quite a number of spin-off effects that would be very positive for developing the rule of law, for bringing a trial closer to the people. Clearly, people in The Hague, prosecutors, investigators would find a difficult security situation. I recognize that. Also, if you've lived in The Hague, you might not want to spend 3 years in Tripoli. But at the same time, this was an opportunity to think differently about what the court might do in domestic situations. And perhaps we still have that opportunity to do that. Okay, so I'm going to put Libya aside, and I want to focus on several thematic areas where I would say there could be lessons learned. I fear that I'm going to have to get through these very quickly, so I'll sort of Federal Express these in. So the first lesson learned is that the ICC is a fishbowl. It's literally a fishbowl if you go to the court and you're in that gallery and you have a lot of people watching you do your work. But prosecutions at the ICC, much more than the ICTY or the ICTR, I think, are very, very closely observed. Prosecution tactics are analyzed, they're critiqued, they're even mocked by an assortment of bloggers, journalists, activists, and academics. We instantly debate charging choices. Think back to the decision to charge Lubanga, for example, with child soldier violations only. When that happened, there was really an outcry from the activist community, from others in NGOs, about why there were no charges against Lubanga for sexual violence cases, considering that many people thought those were provable and that there were connections that could be made there. But the general point that I want to make is that for prosecutors at the ICC these days, everything you do is observed and critiqued. Now, related to this is a second lesson learned, and that's the issue of transparency. So 10 years into the life of the court, we have only a weak sense, I think, as to the factors that go into OTP's analysis of when, to give an example, preliminary examinations should move to formal investigations. Human Rights Watch, just about a year ago, produced a really excellent report on this topic, and I want to just quote from its report specifically. So HRW identified a few things, including, quote, limited public reporting, lack of clear timelines for carrying out its analyses, and in some cases, years-long processes without a decision, and overstating at times the prospects of ICC action in a manner that may have credibility and due process implications. I think that the court could have gotten away from some of the problems in this situation, in the situation of preliminary examinations, by being a bit more transparent about their process. The example of the Palestine examination, to me, perfectly encapsulates this problem. For over 2 years, the submission from the Palestinian Authority sat with OTP, only to result recently in a 2-page statement of the decision not to move forward with a formal investigation. That may very well have been the right answer, but we have no indication why it took so long to answer this very direct legal question. Third, on the lessons learned, just say no. It seems to me that OTP hasn't felt strong or confident enough to say no in certain situations. Maybe this is changing, and maybe my examples will be from the early days. But I do want to take the self-referrals of Uganda and the DRC. I think these are very important situations that deserve the attention of domestic or international justice. However, the impression from the outside, and I am speaking as the outsider, so I welcome the opportunity to be corrected. The impression from the outside is this: OTP has taken on these situations by choosing, or by default, by being able only to focus on one side, whether it's the Lord's Resistance Army in Uganda, which is obviously now famous, made famous by Kony 2012 and Invisible Children, or the militias in the eastern DRC. I may be wrong here, but because of the lack of transparency, I cannot say that the court is putting any definite attention on the governments in these situations. Unless the prosecutor believes that OTP will have access to conduct investigations of both sides in a conflict, I think it should say no to self-referrals. 4, political supervision. So this is less about the operation of the court itself and more about, and probably the registrar will feel this most acutely, the kind of political supervision and financial supervision that we get from the Assembly of States Parties. So I think that the Assembly of States Parties, the ASP, has provided weak supervision of the court generally, and even when it does provide supervision overall, it also holds back some of its support. So for example, in the most recent ASP, the budget is a budget of 0 nominal growth, so not really allowing for the full growth of the kind of court that we may need. So one of the problems is that there's really no obvious mechanisms for accountability when prosecutors or judges get things badly wrong, whether it's personal or personnel or mismanagement. And for an institution that's devoted to accountability, I find it deeply problematic that we don't have that kind of accountability mechanism in the ASP, or at least one that really operates. It's true that there have been ILO decisions that have been costly to the court, but there have been no implications for leaders in their aftermath, and I think that needs to change. 5, supporting national jurisdictions. This goes back a little bit to my point about Libya. Simply by example, the court can help in developing the rule of law in domestic settings, particularly in post-conflict settings. Over time, the court has learned that building public support in the countries where it's focused is crucial for practical reasons of witness protection and for more general reasons of building support for the rule of law. The court has little capacity, it's true, little capacity, in part because of the ASP's decisions, to assist national prosecutions. But there needs to be, I think, more serious thinking among all of the stakeholders in international justice about the ways in which the court can integrate into national mechanisms, whether they are prosecution-oriented or other mechanisms such as truth commissions and inquiries and so forth. Okay, 6, a strategy for external support. From the vantage of an observer, it does not appear that the court, despite the JCCD's existence, has had a definite strategy for developing external support, apart from meeting with governments and making the case for support in individual situations, which it clearly does. External support needs a strategy that might be seen as political. This is a risk of seeking political support, right? And I think that anybody who followed the career of Carla Del Ponte as the prosecutor at the ICT-Y would see that when she tried to get political support, sometimes she got burned for it. But I don't think there's any way around developing a strategy for getting support for the court. It cannot just be, sadly, it cannot just be a moral case that government must support the court, or even just a legal case that Rome Statute parties have an obligation to support the court. There has to be some use of political power, which I think the prosecutor enjoys. It's very tricky, but I think it's critical. Now, I'm going to wrap up in a minute, but I could continue. Maybe Alan could develop a course around this. But there are other observations I would want to make on the importance of things like managerial skills, an assessment of judging, which I think deserves very close attention, the need for strong working relationships and respect among the prosecutor, the president and judges, and the registrar. There are many things, other places I could discuss. But I want to close with this probably self-serving remark, and that is the court should be open to criticism. There's a sense among observers, and I say this having talked to many people in the NGO community, those who are very strong supporters of the court, even the most ardent supporters of the court, that criticism hasn't always been taken in the constructive spirit in which it is mostly given. There are many, many stakeholders in the ICC, and the court, I think, needs to be alive to all of their concerns. So with that, thank you very much.
Thank you, David. And now I'd like to open the floor up to Mr. Benjamin Ferencz.
Thank you very much. I see the instructions are that I'm supposed to look backward and forward, telling you about the International Criminal Court. You've listened all morning to all kinds of technical discussions. I know from wandering around the audience and asking them what they thought I should talk about that we have a very mixed audience. So I think the best I can do is perhaps give you a quick overview. We've only got about 25 minutes in which to conclude, and then our whip comes out, and you get the questions. Just to give you a quick overview of what it looks like, let me give you some background. If you need more details and are suckers for punishment, you may look at my website. It's my name, Ben Ferencz, one word. You'll find books all available free, articles, lectures, DVDs, CVDs, BIDs, I don't know, SOBs. And you'll find all of it there, more than you can have time to read. It's taken me about, I don't know, 70 years to do all that. But let me give you a little bit about my own background, so you know where I'm coming from and what the biases are. My parents came to America as poor immigrants, fleeing persecution and poverty in Romania and Hungary. I was an infant child, lived in dire straits, let me say, in the slums of New York, Hell's Kitchen. Managed somehow, with the grace of the United States, to find myself in Harvard Law School, where I won a scholarship on my exam on criminal law. I am eternally grateful to the United States for the opportunities that it gave me as a poor immigrant boy. I joined the Army when the war broke out. I had, at law school, for the benefit of the students, worked as a researcher for one of my professors, Sheldon Gluck, who wrote the only book at the time on war crimes. I was a great expert on war crimes, so the Army immediately made me a private in the artillery. And it was in that capacity that I landed on the beaches of Normandy and was chasing General Patton, or he was chasing me, I'm not sure which, all across Europe to the final battles of the Bulge. The war ended. I was given an honorable discharge, which surprised me, as a sergeant of infantry, and given 5 battle stars for not having been killed in all these battles. I appreciated not being killed. Very shortly thereafter, I was invited to come back to Washington, come to the Pentagon. They called me dear sir. Oh, they'd never called me sir in 3 years. And they wanted me to go back to Germany. And I said, me go back to Germany? Are you kidding? You have to declare war on Germany and be losing before I go back. They said, we need you. We need you. What for? The Nuremberg trials had started. Justice Jackson was already in swing. I had been involved in the early days of the U.S. military commissions. I had been involved in collecting evidence for those commissions, which meant going into the concentration camps as they were being liberated. It meant digging up the bodies of American flyers who had been shot down, and others. It meant picking up the pieces of friendly fire when we shot down some of our own planes. And all of the horrors of war, which I don't have time to go into, and I have no need to go into, but it certainly made a very deep impression on me, which has not yet gone away, and that is that war is a terrible thing. It is not something which is glorious. It is not the path to power. It's not the path to privilege or conquest as being a great thing. It's awful. And that point of view is not something unique to me, because I can quote General Eisenhower, who, when he was President of the United States, said that the time has come for us to recognize that we have to give up force and rely only on the rule of law. And General MacArthur, who just come through hell in Japan, the same effect. So these great American generals preached a doctrine which I accepted wholeheartedly and which I have been pursuing ever since. To show you it has been mentioned by Professor Stacy that I was the chief prosecutor in one of the subsequent trials. We had 12 trials after Justice Jackson's International Military Tribunal was over, because we wanted to show a comprehensive picture of how it could be that a country as civilized as Germany could allow all those things to happen. So we had trials against doctors for medical experiments, against the lawyers and the judges who perverted justice, against the ministers who had lied, the diplomats who, in order to continue their conquests and their aggressions to all the countries in Europe, and against the SS who carried out the murders. Well, I was appointed the chief prosecutor in the Einsatzgruppen case, which nobody can pronounce or translate. These were special extermination squads, our class will tell you about it, who went in and killed. Their assignment was to kill all the Jews, men, women, and children, and do the same to the gypsies. and we'd captured their daily reports. How nice, top secret. I took a little adding machine, added them up. When I added up to 1 million of them murdered that way, this was in Berlin, I was doing research for all the trials. I flew down to Nuremberg. I said, General Taylor, we've got to put on another case. And he said, no way. Pentagon hasn't approved it. We don't have staff. We don't have money. We don't have funding. I said, look, I've got here cold-blooded murder, and I can prove it every single day what they did. He said, can you do it in addition to your other responsibilities? I said, sure. He said, okay, you're it. So there it was. I became the chief prosecutor in the biggest murder trial in history. I proved that the 22 defendants were responsible, including 6 SS generals, and many of the people with PhDs. I selected only those with the highest rank and the highest education. No enlisted men in my dock. And I proved that they had murdered over 1 million people in cold blood. 13 of them were sentenced to death. I was then 27 years old. I rested my case in 2 days. It was my first case. I didn't need any witnesses. I said, I got the best contemporaneous documents. I don't need witnesses. So I guess that was a rather historical event. But there's another historical event, has been mentioned by Mrs. Batohi. My second case was last August. I'm invited by Marino Ocampo, and he said, Ben, will you please come up and wind up and close our first prosecution against Lubanga. And so I made the closing statement in the Lubanga case. The first one was I was 27, the second one I was 92. So if you're looking forward to a busy practice, okay. Well, what did I learn from all this? I learned quite a bit. I learned that it's a horrible world, really, and that the argument that the rule of law should substitute for force is a correct argument. My website has law, not war. This is a law school. I would expect that people would recognize the wisdom of that. And you'd be surprised how hard it is. And you've heard some of the arguments. So let me come to the conclusions. What conclusion have I come to? All of you who've been following this, and there's not many of them here in the audience, know that the effort to create an international criminal court, which I wrote about, I guess in 1920 or 30 or so, it was 1940. Everybody said it's impossible, it'll never happen, war is inevitable. Some said war is glorious, God's will, the big fish eat the little fish. You're wasting your time, you're on a fool's errand. They called me the man of La Mancha, and all kinds of other names. And what do you know? We have an international criminal court. And you know what? It's working. Now, you've heard the comments, all kinds of suggestions for improvement. They're all valid. It's a tough job. You've got to do translations in a foreign country. You're fighting in Congo somewhere with a tribe which speaks your own intellect. How are you going to find them? You've got to get approval from the registrar to hire translators. You can't find translators. You've got to worry about bringing the witnesses. The witnesses are liable to be killed. You have to protect them. It's a very complicated business. The suggestion made by my memory for names is just falling apart. David Kaye is of course correct. You know, you have to simplify it. You have to improve it in all kinds of directions. You have to pass the burden on to national jurisdictions wherever possible. It's much more sensible to have it be done locally. Well, first of all, we needed a condemnation of war-making itself, and I worked on that harder than anybody alive, dead or alive. My argument simply was that aggression is a crime, and the punishment should be for those who are the aggressors. And I wrote lots of books on that. My wife read them. But the United States, principally, not alone, said, look, we don't need any court to tell us what to do. Certainly not a new court. And America is a great democracy. It's inevitable that there'll be people with different points of view. And I have to respect those points of view. They're a sizable minority or whatever they are. And so this was knocked back and forth for a long time. And the first time was in Rome. Before we got to Rome, people were saying to me, Ben, drop this aggression thing. You're going to sink the whole boat. Nobody's going to accept it. Nobody's ready yet to give up the right to go to war when they decide it should be necessary. And I said, no, we're not going to drop it. We're going to keep going with it because it's right. And sure enough, we got to Rome, and what do you know? They didn't drop it. They said aggression is a crime. However, please, we have to define it. We can't punish anybody for something which hasn't been defined. Well, that would be a perfectly sensible argument and very persuasive if it were true. It wasn't true at all. It was a lie. It was a plain, ordinary lie. Now, the diplomats would say it was disingenuous. That's a big word. I came out of the army. I said it's bullshit.
That's a shorter word.
So, because we had a consensus definition, I sat through those meetings for, I don't know, 15 or 20 years, and finally in 1974, they have a consensus definition of aggression, worked out, consensus definition. The chairman, Bengt Brons of Sweden, invited me to come down. I was the only guy in the balcony. No, we didn't have NGOs like today. He said, come on down here, Ben, you stand with us, this is your work. And so by 1975, immediately I was ready. The next day, 2 volumes on defining international aggression. My wife read it. I don't know if anybody else read it. So there we had a definition. Nuremberg had a definition. They didn't punish those guys with no definition of the crime. The International Law Commission went into that for great length. They came up and said the Nuremberg definition is fine. So where did they come off? It hasn't been defined. That's just a convenient excuse to justify not doing what they don't want to do. Okay, comes Kampala. The main point in Kampala is how are you going to amend the statute to redefine aggression and make sure that the Security Council's veto powers are preserved. Because if they control everything, well, they got to worry about. You got to get their permission, including the big powers. So those were the main sticking points. They come to Kampala, and I go to all these meetings. That's how I used to be 7 feet tall. This wore me down. So we get to Kampala, and what do we do in Kampala? We do the same thing we did in Rome. Postpone it. Put it back to 2017. But that's also a little bit deceptive. It says not before 2017. It could be 2097. We got an invitation here. I should come back here 10 years from now. I'll accept the invitation, but I don't know whether I'm going to be able to manage it. So again, they pushed it off to an indefinite date. The Supreme International Crime, as it was called by the International Military Tribunal, approved by the General Assembly of the United Nations. And it is. All the crimes are committed in war. If you've been a soldier, you know. Rape is a trophy of war. Women want to stop rape, stop war. All the crimes are committed in war. Burning, pillage, murder, rape, you name it. Child soldiers is child's play compared to what happens when you have a war. So they postponed it again. Now, you may have gathered I'm a persistent fellow. And I said, all right. We're going to accept that. I mean, you know, it's a fact. I'm not going to go around screaming at the United States or anybody else, for that matter, if they have a different opinion. They're entitled to have a different opinion, and it's entitled to be respected and dealt with on the merits. Let's consider it on the merits. War is a terrible thing. It's a crime against humanity, isn't it? I look in the statute, sure enough, we have crimes against humanity and other inhumane acts. Other inhumane acts? What could be more inhumane than sending young people out to kill other young people they don't even know? And killing everybody around them at the same time? Because the weapons that we have, they're not that precise. You're aiming for one very bad guy, and in the process, you kill 100 people who happen to be in the house with him or even in the hospital with him. That should be a crime against humanity. And so I said, let us not worry about aggression. If they're going to deal with it in 2017 or thereafter, fine. But in the meanwhile, the perpetrators of that most serious crime are immune from prosecution by any international court, or any national court for that matter. I don't like the idea that someone can plan what was condemned in the various definitions of aggression as bad acting, can't be tried by some court. What kind of a system are we running? But if you're able to charge him with crimes against humanity as an other inhumane act, of course you have to guarantee him the ordinary rights of a fair trial. He must know, has knowledge and intent of what he's doing. The judges must take into account all of the circumstances, including the possibility that it's mitigating circumstances. There's a responsibility to protect in a situation where human rights are being grossly violated and the Security Council doesn't respond. The judges have to, they're required by the statute to take all of those things into account. We did in Nuremberg as well, as mitigation. Either they decide not to try him under those circumstances, or they mitigate the punishment. So all of those protections have got to be built into the crimes against humanity, isn't it? I look in the statute, sure enough, we have crimes against humanity and other inhumane acts. Other inhumane acts? What could be more inhumane than sending young people out to kill other young people they don't even know, and killing everybody around them at the same time? Because the weapons that we have, they're not that precise. You're aiming for one very bad guy, and in the process, you kill 100 people who happen to be in the house with him or even in the hospital with him. That should be a crime against humanity. And so I said, let us not worry about aggression. If they're going to deal with it in 2017 or thereafter, fine. But in the meanwhile, the perpetrators of that most serious crime are immune from prosecution by any international court, or any national court for that matter. I don't like the idea that someone can plan what was condemned in the various definitions of aggression as bad acting, can't be tried by some court. What kind of a system are we running? But if you're able to charge him with crimes against humanity as an other inhumane act, of course you have to guarantee him the ordinary rights of a fair trial. He must know, has knowledge and intent of what he's doing. The judges must take into account all of the circumstances, including the possibility that it's mitigating circumstances. There's a responsibility to protect in a situation where human rights are being grossly violated and the Security Council doesn't respond. The judges have to, they're required by the statute to take all of those things into account. We did in Nuremberg as well, as mitigation. Either they decide not to try him under those circumstances, or they mitigate the punishment. So all of those protections have got to be built into the crimes against humanity charge, and there are provisions to that effect in the Rome Statute and as accepted by everybody for all the other crimes. So that seemed to be the next goal, to get recognition that what we used to call aggression, and don't mention the word, it's a dirty word now, because anytime you mention aggression, those who don't want to be tried for it, they say, we already reached an agreement, 2017, don't talk to me before 2017, knowing damn well I'm going to have a tough time making it. We have another name to the baby. We're going to not call it aggression anymore. We're going to call it crimes against humanity, because that's the sense of the whole thing. That's the sense of crimes against humanity. We didn't deal with it before because we said aggression, war making, that's a separate subject. There's separate committees dealing with it. Well, the separate has now been put on ice. The committees don't exist. You're going to take it lying down. You're going to give immunity for the worst killers in the world and just remain silent? Not me. That's where we come to the young people here, the students. It'll take a while. It'll take maybe a long while. But if you're on the right track. And how are you going to do it? You're not going to amend the ICC statute. You may let it be known that the ICC would entertain such a charge, should it be brought. But what you can do is the national legislations. Complementarity sets forth the rule. It's an obligation of nation states to carry out the provisions of the Rome Statute, all those who have signed on to it. And it's a normal obligation of all states not to commit crimes against humanity on any principle. So you've got to get the national legislations putting into their national statutes a provision, just as it says now it prohibits rape and murder and persecution and apartheid and all the others. You put in crimes against humanity includes the illegal use of armed force in violation of the UN Charter and without Security Council approval, subject to there being the requisite intent and knowledge and awareness that large numbers of human beings will be killed in the process. That is a crime, and it should be recognized in the national legislations and encourage the International Criminal Court to let it be known that they would be receptive to that. If you do that, what is the harm done? A country which wants to retain its right to have its leaders, we're talking only about leaders, engage in the illegal use of armed force, doesn't have to do it. If the legislature is not ready to accept it, they don't have to accept it. But we have a little interesting situation then, and we have it now. Who decides whether it's legal or not? Is it the perpetrator of the crime who decides? He's always going to tell you that he did it in self-defense or he did it in defense of national interests. I had a long discussion with the gentleman, I guess he was a gentleman in other respects, name of Dr. General Otto Ohlendorf, SS General, killed 90,000 Jews, as well as others. And he explained, this was self-defense. Where do you come off with self-defense? Germany attacks, Poland, Russia, France, Belgium, all these countries. Where's self-defense? We knew, he said, that the Russians were going to attack us. The Soviet Union was going to attack us. Therefore, we had to attack first. Preemptory self-defense. Well, why did you kill all the Jews? Well, we knew that they were sympathetic to the Bolsheviks. Therefore, we have to kill them too. And what about their children? Well, if they grew up and they knew that their parents had been eliminated, they would be enemies. You have to kill them too. That's a rationale I didn't accept. And Ohlendorf was hanged by the neck by the U.S. Chief Prosecutor for the United States in that trial. And I thought it was a just sentence. Okay, let me wind it up. I have 1 minute warning before I suffer a similar fate. What you've got to do now is work on improving the court. It'll come along. It's a prototype with all the difficulties. You know, the Wright brothers were peddling and they said they couldn't make it fly. Well, we all flew in here. It'll take a while and it can be improved. Work on national legislations. Set up special people to do that job in your universities and in the ICC as well. Assignment to just spread it. It's a legal obligation under the Charter for the ICC to encourage and help the national states. And I think if you do, you'll see progress as well. The progress has been enormous. There has been an awakening of the human conscience. Really, it has. The things that I thought were impossible, everybody said was impossible, have become reality. With problems, of course, with problems. But you face the problems and you resolve them and you move forward and you make mistakes and it costs too much and it takes too much time, of course. But that'll all change. If you do all that, well, then I promise not to come back 10 years from now and haunt you. Thank you very much.
It's such a privilege to have you here. And I was going to ask you how you managed to sit it out from the late 1940s and the International Law Commission making a recommendation about having an international criminal court to ultimately the Treaty of Rome. But I guess a guy that had to wait 65 years from his first to second closing argument had patience down.
I was very busy. I was always very busy, and I'm glad you asked the question because it's something I didn't get to in time. When my trial was over at Nuremberg, I set up, at request of a consortium of Jewish organizations, the whole machinery for compensating the survivors. talk about it as being a big problem. I did not spend a penny on public relations, nothing. It's not very well known. In secret, at Wassenaar, 5 minutes away from the courthouse in The Hague, there were negotiations carried on in 1952. I was legal counsel to them, and an engine in that machine. We negotiated in secret a treaty with the West German government. Chancellor Adenauer, devout Catholic, said terrible crimes have been committed against the Jewish people, which imposes an obligation on us to try to make amends. I set up 3 different corporations over a number of years. One was to recover the ALS property. I was the Director General of the Jewish Restitution Successor Organization. I hope you're impressed with the title, because I gave it to myself. And I was the only employee at the time. However, that grew into the Conference on Jewish Material Claims Against Germany, which negotiated the treaty between West Germany and the Consortium of Jewish Organizations and the State of Israel, which didn't exist at the time the crimes occurred. Very interesting, legal, tricky. And the United Restitution Organization, which was the biggest legal aid society in the world, to help the individuals with the claims, which amount to over 1 million claims. Think you have problems. And from a country which was destitute, totally bombed, people had nothing to eat. Work that out, and I did. So that took a number of years. So that answers your question. I was busy as hell, and I still am, traveling all around the world, trying to save the world. And
we're the lucky beneficiaries. Whilst I have a couple of quick points, please do line up behind the microphones. I wanted to drill in, first of all, to both Shamila and to David on this question of the politicization of the ICC. And as I heard you, you both seem to be accepting that politics is an unavoidable and maybe essential role for the ICC. And I think we're actually all 4 of us prosecutors or ex-prosecutors up here. So I've got some very specific questions. For you, Shamila, I'm asking if you'd be willing to share with us the behind-the-scenes scoop on what sort of evidence and data your office considers. You did, I think, state that the Office of Prosecutions doesn't work in a vacuum, and that you are mindful of the surrounding political issues. Well, without asking you to disclose exactly what you're mindful of, I'm wondering if you would tell us what type of data, what type of information, in principle, you consider. And for you, David, my question is, maybe we can use the Uganda example. On the one hand, you recommend that sometimes the ICC says no when a country is either ambivalent or maybe doesn't have the necessary commitment to surrendering defendants and evidence and forensics and all those other things that are essential for criminal trials. So let's take the Uganda situation. If a country should not, if the ICC should maybe say no, and you also want the ICC to support international institutions, and if you also want the ICC to have a strategy about how it would do so, what, very quickly in 2 sentences, would be your strategy for the ICC vis-a-vis Uganda? So maybe, Shamila, if I could ask you to answer that question first.
Yeah, it's a tough one, but I think I can allude to it sort of, you know, in not a lot of detail. But I suppose, you know, we're in a catch-22 situation, really, the prosecutor's office. And I'm glad Mr. Ferencz alluded to that, because I would, if I said that, I might be sounding, it might be construed as being defensive. Yeah. So I'm very happy for that. But I think we're in a situation where, on the one hand, we depend on the states for cooperation. Mm-hmm. It's one of the pillars of the court is the cooperation pillar. And on the other hand, you want to take a decision that you know is not going to be welcomed by the political heads. So it means you have to take the legal decisions, okay? But what you need to do is factor into these decisions that you take into account the political situation.
I get that. I'm asking you to say, what sort of documents, what sort of newspapers do you read, which policymakers do you listen to? Where do you get your information from to help you make that decision that you've factored in?
We have, as David mentioned, the JCCD, which is one of the divisions of the office. So it's a big component of the office. You have the investigation division, prosecution division, and JCCD, which is jurisdiction, complementarity, and cooperation division. And that division is responsible for external relations. And within that division, their sole function is to liaise with governments, with NGOs, with all kinds of stakeholders and actors in the international and arena that would help us understand what the policies of certain countries are regarding a certain very specific issue. So they are constantly liaising with either at different levels, the desk officers, the ambassadors, and then the ministers if the prosecutor himself needs to get involved, to get a sense of what the state's views are on certain strategic decisions we might want to take. So it wouldn't affect the taking of the decision, but it may well affect the timing of the taking, so that you prepare the ground for when you do make the decision, that it's understood and you can still try to maintain the cooperation that you need. So
answered as a true lawyer. You gave us some, but we know just a soupçon of the insider scoop. David, what's your strategy?
So that's a very easy question to ask. So I would say in thinking about Uganda, we need to think both about what we would have done or what we might have advised as a strategy in 2004, 2005, and what might be possible now. I mean, we're very different situations. So from my perspective, and I also take Ben Ferenz's point that this is very hard work. So I'm not trying to say that there's any easy fix here, but I do think that in 2004, 2005, as part of a strategy, the court should have had real clarity that it could have access to investigations not only of the LRA, but also of government abuse in Acholi land in northern Uganda. I'm not aware that that was a part of the decision to move forward. If you'll recall, at the time of the self-referral, it was a press conference with Museveni and Morena Ocampo, and the impression given, which is part of the strategy, is one of alignment with the government in order to pursue the LRA. And I think that undermines a little bit of the credibility, particularly with local actors in northern Uganda, about what was the goal. So I think at the very early part of a situation, you need a strategy that says we're not going to be influenced by a government that's self-referring. So that's the first part. Right now, we're in a totally different situation. The LRA is not in northern Uganda. There are different actors to work through. I think that the ICC has actually done a pretty good job at generating support among civil society, whether we're talking about Invisible Children or different movements in the United States that got the LRA Act passed a year or two ago, and Ambassador Rapp deserves great congratulations for moving that forward. And so they've been more successful since then. I mean, we still don't have Coney and the others, but I think at least in those terms, that's the kind of strategy that they should be pursuing right now.
And so does that mean that you might want the ICC to have knowledge that the national government has support by, say, local police in capturing people, lining up witnesses, getting the forensic evidence, and building a file? Would you want that before?
I'm not sure you'd need before the actual file, but I think you need that kind of commitment of support, and that support should be regardless of the targets of the investigation. So whether they're LRA or their government, I think that's the kind. In order to have the kind of credibility that the court needs as an impartial arbiter of criminal behavior or determiner of criminal behavior, it needs to be clear to people on the ground and to people around the world that they are focusing on both sides of a conflict, or in the DRC, many sides of a conflict.
Right. Perfect. All right, so same request, if you could state who you are.
Yes.
And direct a very short question to the particular person you'd like to have an answer.
My name is Robert Baker, and I do civil human rights litigation. Right now I'm working with Paul Hoffman on the Kiobel versus Royal Dutch Petroleum case and Doe v. Nestle. And, you know, I wanted to point out, you know, the intense hostility in the United States courts and among international corporations for the work we're doing. You think we're Einsatz Group, and so, you know, that reflects the importance of your work, because if you can't cooperate, for instance, when there's a favorable response from the United States government, and if the ICC can't reduce its time to trial and take more cases, I don't know. Really,
we need a question.
Yeah, how can you maximize the amount of work that you can do, bearing in mind that, you know, 5 years from now you may be the only game in town in the international human rights area?
And that's for Shamila. Let's hope that's not right. You're the only game in town in 5 years' time, but
I think I've kind of alluded to it, is the fact that the court on its own, you know, cannot really do everything that the international community expects it to. We really need other stakeholders to be doing their part, whatever it might be. And ideally, if all states actually, as Mr. Ferencz even said, states parties, states non-parties, actually have legislation to deal effectively with these kinds of crimes. At the end of the day, we could be very effective because the court would have a limited number of cases to deal with, given our serious resource constraints. And the rest of the world would be dealing with these types of atrocities effectively. So I'm not sure that I'm answering your question, but in order to maximize the impact of the court, we really need stakeholders to be, and not just domestic courts, but we need political players, we need NGOs, we need civil society, we need students, we need everybody. And we need this, as I mentioned, we need this comprehensive strategy to work together to actually deal with these things. If people look to the court and think that we are this magic wand that's going to really solve all the problems of the world, then I think you're mistaken, because we really can't do it on our own.
Hear, hear. Yes, thank you.
Thank you. I have a question for Shamila and maybe for David, given your time at the State Department. I appreciated what you said about the challenges of cooperation and enforcement.
Just speak right into the...
Sorry, yeah. And I wonder if you have thoughts on suggestions or ideas on how the court can better deal with the challenges of enforcement, and specifically if you have thoughts on the utility of the model that the U.S. government has used with rewards for justice, which I know was operational both with the ICTR and ICTY, and it was reported just a couple days ago that it may be expanded for CONI as well in Uganda, not related to the ICC, but if that's a model that may be applicable and useful for the ICC.
So for those who didn't hear, the question is, how can ICC action be better enforced? And I think more enlarged is how can, is there any traction in the rewards for justice programs that the ad hoc tribunals instituted?
I think, you know, any kind of initiatives that support us in particularly bringing to the court those that are, you know, still the subject of arrest warrants would be, the court will take any cooperation. There was also, I mean, the U.S. was going to put together a team to look at arresting CONI, you know, and of course we were all excited about the initiative. And so I think from our perspective, we can't, as the judge said, we really can't dictate what kind of cooperation we'd like from states. But JCCD, the division, in their interaction with states, would actually give an indication of, you know, the kind of assistance that would help us in, you know, kind of a joint strategy that would help us. But at the end of the day, it's, you know, really the states decision in terms of how they can, in whatever way possible, support the court in terms of, particularly arresting those that are, still the subject of arrest warrants.
David, did you have a response on the enforcement issue?
Yeah, I'll just say very briefly. I think rewards for justice can be an effective way to incentivize local populations to try to flesh out connections and networks that support those who are subject to arrest warrants. So I think that's important. I'm not sure there are governments right now that are going to provide that money, so maybe there are foundations that want to put that money forward. The other thing is to focus on the P3. I think we talk a lot about the problems.
Say what that is.
Of the permanent 3 members of the Security Council. So, in particular, the UK and France, because they are members of the Rome Statute already, but also the United States, and focusing on them and developing a strategy that the P3 really work towards developing cooperation, because it's really not something the ICC can do on its own. It really requires, first and foremost, the UK and France to be providing real, concrete, logistical and other kinds of support.
And Benjamin, you
we have mentioned the, I think, very important point that the new information revolution, which is taking place now, is going to have a tremendous impact on this. The things that you were mentioning, David, and the others, correct. The governments are reluctant to act, and the ICC cannot act. But if you can generate enough public support, as you did in the Coney case now, something along those lines, all of a sudden, everybody in the world knows you've got a court, and you've got to do this, and you've got to do that. That will influence politics. Nothing has changed yet. You don't want it overnight, too fast. Got to be patient, like me. Come back 60 years, you'll see. It's really going to change very radically. I don't know how fast. As the public wakes up, and I've always been made the plea of humanity to law, that they've got to have change. They're going to put the heat on the politicians, nationally and internationally, and then you're going to see the changes. Then we're going to move forward. Or else maybe I'm wrong. You'll blow yourselves up. Goodbye.
Thank you. Could you state who you are first?
Yes, Sean Butler. Thank you all for being here. I hope my question's not too specific. In the Lubanga case, the court really discouraged the use, disapproved of the use of intermediaries. And you don't always have the documents like you have when the U.S. had taken control already of the camps the Germans previously had. How do you deal with the situation where there's the conflict, where you don't have people who are on the ground, you don't have local enforcement supporting you, and now, apparently, you're not supposed to use intermediaries?
Well, the court hasn't decided that we shouldn't be using intermediaries. We're still committed to use intermediaries. But I think the lesson that we learned from Lubanga was that we needed to rethink the way we used intermediaries. And I think we've realized Lubanga was the first case that we investigated and the first case before the court. And we accept that there were serious mistakes that were made by the investigators in terms of how they use intermediaries. And the problem was, one of them was the fact that they overused intermediaries, and there was very, very little supervision. So they built a kind of relationship of trust with intermediaries and then allowed them to actually do more than they should have. And that burnt us at the end. What we've now done is we have operational standards, and I'm in the office also responsible for the operational manual that we've just drafted. The use and supervision of intermediaries is very, very clearly set out, and the very specific tasking of intermediaries. So we still use intermediaries, but we use them very differently. They are supervised, they are performance managed, in a sense. And if there's at the very first indication that there could be a problem, we would not continue to use the intermediary. So we've learned a tough lesson, but hopefully we've put in place sufficient safeguards to ensure that it won't happen again.
Thank you.
I'm Eloise Rosenblatt, attorney in private practice, but very concerned about the international rights of women. One issue that hasn't been raised here is on the issue of stakeholders and Muslim nations. What way have you found effective to bring on board countries that may describe themselves as Muslim nations when the history of the International Court, its roots in Nuremberg, its location at The Hague, can be perceived as a Western Northern Hemisphere institution? What are the ways you've found effective to appeal to Muslim nations?
Well,
That's a really good question.
Mm-hmm. Well, what I can say is that the prosecutor interacts with the Arab League and has developed a relationship with the Arab League. So to the extent that we need to liaise with them, and it's important that we do, that relationship is established. He also has been establishing links in Qatar, and so certainly the Office of the Prosecutor is acutely aware that we need to establish these links, not just in that community, but certainly in various parts of the world. But I think our strongest link there is perhaps the relationship that the prosecutor has and the office has with the Arab League.
Could you say more about what that relationship is constituted of? Again, the inside scoop, if you've got it.
Well, I think it depends on the issue, and at
Honour killings.
Say again?
Honour killings, or is that seen as
I'm not quite sure that was on the agenda, but I think it depends on what the issue is, and I have not been privy to those discussions between the prosecutor and the Arab League, but I do know that he has them from time to time, and I think it's the mere fact of the relationship is a positive indication. So I think I'll leave it at that.
David, did you?
Yeah, I just wanted two things on that. I'm not sure where the questioner went. One is, so the head of the Arab League right now is Nabil Al-Arabi, who's used to sit on the International Court of Justice. He's actually, I think, supportive of the ICC. So we're actually in a moment where the kind of support that we could get from the Arab League is now. I mean, if there's ever going to be a moment, it should be now. And we actually saw it in the context of Libya. In fact, the Security Council probably would not have moved to referral had the Arab League not expressed its support for that referral. So I think there are positive things going on. Clearly, some of the groundwork had been laid by the ICC. The other thing I'd just say very quickly is civil society plays a very important role in this context. And in particular here, it's the CICC, the Coalition for the ICC, which its mandate really is the universalization of the court. And so some of these things, I think, Shamila identified as the ICC really needs to push, but they also really need to rely on outside actors, not only the CICC, which may be seen as Western-oriented, but also local affiliates of the CICC and other organizations.
Don't go away. There's just one last comment, and we want your question.
No, I want to add to a point which hasn't been made. I think that will cure itself in time. As more cases are handled, it'll be recognized that it's not just directed at one particular segment. But we haven't really noted adequately that you're never going to be able to try all the criminals. This is only a meager sampling, as it was in Nuremberg. The Einsatzgruppen trial, I tried 22. There were 3,000 killers. The rest of them, nothing happened to them. So the value comes in the deterrent effect of preventing others from committing the crime on the threat that they might be sitting in the dock. And deterrence, Marino Campo has said he would like to be out of business. Let the national courts handle it. Because by the time you've got a case, you failed. And so we have to see what the deterrent effect is. And whatever you do, it's a sampling for the others, a warning of things to come.
You keep recalibrating us with the arc of history, Benjamin. It's terrifically, terrifically helpful and inspiring and optimistic. Yes, please.
My name's Susan Diamondstone. I'm an attorney in private practice in Redwood City and the San Francisco Bay counties. I practice in the areas primarily of family law and employment discrimination law or employment law. And from time to time, I do get cases that sound internationally, either because they involve family law decisions from courts in other countries, including Sharia courts, or because I have employment law cases in this country involving corporate employers that do business internationally. I think the largest one I had was one involving a German parent corporation that is very old and very large. The question I have goes to what sources of law does the court look to, and I would direct this particularly to Ms. Batohi, I hope I'm pronouncing your name correctly. In addition to the Treaty of Rome, to what extent do you look to the other international courts sitting in The Hague? To what extent do you look to the procedures and substantive law of the Nuremberg tribunals? To what extent do you look to the traditions of European law, which are based in the Roman law system? And to what extent do you look to the traditions of the common law countries, not only England and America, but other common law countries around the world, or other legal systems in drawing your substantive law from both procedurally and the substantive law you apply as to what constitutes violations of international criminal law?
So what's the precedent and jurisprudence to which the ICC looks?
I also head up the legal advisory section, so if there's any question of law that comes up either by the investigation teams or the prosecution team, then if the executive committee decides that it's important enough for us to research it comprehensively, then we would. But the Rome Statute allows us to actually look into all of the jurisprudence of all of the entities you've mentioned. So essentially, depending on the issue that we have to deal with, and look, the court is a new court, so we don't have established jurisprudence. We will depend very heavily on the jurisprudence of the tribunals and of other international courts, whether it's human rights courts. And to the extent that we need to, we might even do a comparative exercise with regard to different domestic jurisdictions if there's nothing much in the international arena. So the simple answer is that depending on the issue, yes, we look at all of those precedents, and they all depend on the relevance, and it's all taken into account. We don't have jurisprudence of our own. The court is still developing it, but in the meantime, yes, those are all really important.
Before I close, I wonder if any of you would like to reflect on the CONI 2012 Invisible Children YouTube clip that went viral. I'm guessing that most everybody here in the room jumped onto YouTube and clicked on it and became one of the 50 million, then 70 million, and then it went up. It was a viral campaign that seemed to grab the world's attention, and then it seemed to go poof. Does it matter, first of all, that it occurred? Does it matter that it went poof? Does it matter that it occurred after there had been 8, 10 more years, if you want to go back to other wars, of knowledge in the international community about the egregious and awful and hideous nature of conscription of child soldiers? Comments, and I'll just start from the left and work my way down.
It's a great question. I mean, it would require a full seminar to talk about all of the different implications of CONI 2012. The only thing I would say is, on the one hand, it's done a great service by identifying the ICC as a relevant political and judicial actor to millions of people. And so on that front,
advertising.
Right, it's great. It is great advertising. I mean, I think it does a disservice to the extent that it suggests that that the ICC is the only actor involved in providing justice at a local level. And as we talked about the last panel on complementarity and in other places, what really needs to be done beyond Coney is building, and really this has to be locally owned, building national jurisdictions, effective courts, effective systems of rule of law. And to the extent that this sucks the air a little bit out of some of those other efforts, I'd be concerned. But I mean, overall, it's a pretty good commercial for the ICC.
So thumbs up, Shamila?
I think, yeah, essentially what it also showed is that something really simple, and you know, young people could do so much to actually highlight important issues like that. So I think, yeah, it was, in a sense, free marketing for the court. But it also shows, you know, Mr. Ferencz talked about this information explosion. It showed how we could actually more effectively use the social media to actually raise awareness of these kinds of issues. So I think, yeah, you know, it was all in all, I think it shows that we can use very simple tactics to send out a very powerful message. And I think to that extent, it was really awesome.
Like phone apps in the Congo for women who think they're going to be raped. This is Brave New World. Yeah. Did you have any reflections you'd care to share with us?
Yes, I know that he will be captured. I hope that he will be given a trial and not murdered for trial. And that gives me some concern because there are precedents to the contrary, which seem to be accepted.
Recent precedents.
Recent precedents, yes.
Please join me in thanking our wonderful guests.